Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing costly mistakes in divorce and how to best avoid them. And we are very grateful that you were all able to attend. As a member of the Colorado community for over 25 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to that community. Now I would like to introduce our presenter today, Rich Harris. Rich is the managing partner of the Harris Law Firm and is widely respected throughout Denver's legal and business communities for his decades of service and commitment to justice. He has a true passion for family law and uses his experience and knowledge to help others navigate Colorado's legal system. Rich has been recognized by numerous leading legal organizations and is regularly featured as an expert in family law in the media. Without further ado, Rich, I'll turn it over to you.
Well, thank you very much, Izzy, for that very, very kind introduction. And thanks to each and every one of you for joining us tonight. I'm so glad that you did join us. This is a topic that I like to talk about because what we've seen over all the years in doing this important work, sadly, is a situation where people are repeating mistakes again and again. And we're not talking about little things. Tonight, we're going to talk about big things, but I'm not going to present anything that's complicated or super sophisticated. This is just concrete, we think important information that will make a big difference in your proceeding. Let me preface my remarks also by saying the following. Whenever we have an opportunity to meet prospective clients prior to filing for divorce, it's a really good thing because there are a lot of things that you can do, both in terms of preparation and in terms of your mental outlook, that I think can make an enormous difference in your case. It is, of course, not always the case that people come to us prior to filing. And frankly, we come into cases sometimes right in the middle, either because we're taking over from another attorney or the client is just hiring an attorney midstream. We can always help, we believe, but the sooner that we're able to intervene, the sooner that you, if you're contemplating one of these proceedings, and my empathy for you if you are, but also my kudos to you for getting prepared. You can really do a lot to help yourself, and that's what tonight is about, really arming yourself with some important information. So with that, let's go ahead and get started. First of all, here's how I'm going to organize my remarks for tonight. We are going to talk about categories of mistakes, not necessarily in order of importance, but just to help frame how to organize these different things. And I've cut them or put them together in terms of three categories: the people you surround yourself with, the decisions you make, the tactics you take, if you will, in your case, and finally, and perhaps even most importantly, your focus during the case. And I'll have some thoughts to share about that. Incidentally, as Izzy mentioned, at the conclusion of my remarks, I'd be delighted to answer as many of your questions as I can. We'd only ask that you keep your questions more of a general nature. We know that there are folks from all different walks of life on the call. Again, welcome. Thank you for being here. And hopefully what we're providing tonight is of the greatest benefit to the greatest number of folks. After the Q&A, you'll have some information on how to get even further advice if that's what you want and need. Okay, so let's start with your people, your team. When we talk to our kids and we give them lessons about making sure they have the right people around them to help them through the challenges, we talk about the people on the bus, right? So this is some commentary about your own people on the bus, if you will, having the right people and being careful about the people that you bring into your circle during this incredibly important point in your life is really, really important. Let me make a couple suggestions if I could. First of all, I believe that it is possible for folks to represent themselves actually in a family law proceeding. And frankly, it happens all the time. The courts have many, many cases where one or both sides do not have an attorney. And by the way, our firm supports that. We offer something called unbundled services, which I can talk about in a few minutes. That allows folks to get legal advice without fully having an attorney. I do think, and perhaps I'm biased, it's my profession, I get it, but I do think that if you have children, if you have a retirement plan, if you have any significant assets or debts or tax issues, it is very, very important to get a good family law attorney, either to be fully retained to represent you all the way through, or to at least get advice at critical junctures along the way. Now, I don't just say hiring an attorney, and I want to be clear about this. Not every attorney is suited for this kind of work. Not every attorney is competent to handle this kind of work. Sadly, not every attorney has the ethics, in my humble opinion, to handle this important kind of work. Those of us who have been practicing family law for a long time, such as myself, we've chosen this practice. We've specialized in this practice. We care very deeply about our clients. And this is a fairly complex area of the law. So you don't want to choose somebody unless you're comfortable that they have the requisite skills, time, and ethical capacity to do it right. What I can tell you without any hesitation at all, based on going on 3 decades of doing this kind of work, can't even believe it when I say that myself, but yeah, I've been doing this for almost 3 decades now. And we represent many people who did not have an attorney the first time around, or had a poor or unethical attorney the first time around. And I can tell you that it typically costs much more money, time, heartache to fix the mistakes than it would have cost to hire somebody good and do it right the first time. I think almost half of our practice is what's called post-decree divorce work. Post-decree means you're going back to court to change or to fix something from your existing divorce orders. They're often called permanent orders. They're often found in a separation agreement. But when you go back and those prior documents are drafted poorly, or they're missing information, or they're vague, or the orders are any one of those things because there was poor representation, it is almost always a very difficult thing for the client. So like your mom probably always said, I know mine did, better be safe than sorry. I really think you need to do it right the first time around. You should know that if you choose to represent yourself at any point in the proceedings, that Colorado law says that you will be held to the same level of competence as if you were an attorney. And that's kind of a scary thought, in my opinion. A lot of the judges out there will be accommodating, they'll be friendly, but under Colorado law, they're not allowed, or certainly not required, to give you any breaks. The rules of evidence apply, deadlines apply, Child custody determinations are made based on the law. You don't want to make a mistake. You don't want to assume that just because you don't have a lawyer, that the judge or, gosh forbid, the other attorney is going to help you out. They will not, they cannot. So please, please be careful. Beware of getting forms online. You've all heard the ads, I'm sure. There are lots of companies that are out there to chase your money and to try to convince you that lawyers are too costly and greedy and unnecessary. And by the way, all those things might be true in a lot of situations, but don't fall prey to this advertising, because even if that's true too often with a lot of lawyers, it doesn't mean that your problems are going to be solved by do-it-yourself forms online. It's often a scam. You're often using forms that are cookie cutter. Colorado family law is governed by Colorado statutes and Colorado cases. You can't just buy national forms and assume that they fit and they're workable. And by the way, here's another point. The forms that you can file are actually available for free online. And I can tell you exactly how to find them if you want them. There's a link right from our website. And we can give you the forms. We're not going to sell you them. Don't waste your money. Just be very, very careful. It's not a solution. I referred to this concept a few minutes ago about unbundled services. Our ethical rules as lawyers have loosened up in recent years. And for the first time in recent years, we lawyers can provide piecemeal advice or unbundled advice. What that means is you can actually purchase a lawyer's advice on a pay-as-you-go basis from a lot of firms, including our own. It's certainly not as comprehensive as having a lawyer on call that goes to court with you, that negotiates for you, for example. But I would say that it's a heck of a lot better than nothing. And you really can help yourself by at least getting some advice in your proceeding. And not to scare you, but again, it's just my opinion. And I tell you this, not because you need to come hire me or any of the lawyers in our firm. I just care about this work. I've been doing it too long to see too many people get the raw end of things. Child custody, property division, taxation, financial issues. These are not easy things to deal with under the law. Even for educated people, it's not a matter of whether you're educated or smart enough. It's just this stuff requires a good familiarity with our laws and cases and the judges out there. So please, please be careful. The next kind of person that I think is really important to have on your team. I encourage folks to gather a team of trusted advisors around them. So I started with the lawyer. Now I'm going to go on, I should say, to the financial advisor. It's really important that you have independent financial advice. Please know that if you've been married for a number of years and you've worked with a financial advisor for you both as a couple, even somebody you like and trust, in most cases, it's a conflict of interest to use that same individual to just give you independent advice. Doesn't mean you can't work with them and talk to them and do certain things, but I strongly advise folks to seek out a new and independent financial advisor that has not worked with your spouse. That's the way you can get your own independent legal advice. I think this is especially important in cases, and we see a lot of these, where folks are needing to manage money, perhaps for the first time in their marriage. In most marriages, one spouse or the other is the one that does the bills, manages the vendors, the investments, what have you. It's really important. We've seen horror stories with folks who really are not financially ready to handle the important decisions that are needed. We think independent legal advice, financial advice is really, really important here. We think it's important to bring those folks in right from the beginning. It's not just to do what might seem the obvious here. So you're divorced and you all of a sudden have assets and investments to manage. Maybe you need advice on where to put those. But there are important financial considerations before and during the process as well. If you're going to need to hire somebody anyway, we strongly recommend you bring them in early and have them available during the proceeding. The next category of folks out there are folks that are there in your corner from a mental and emotional standpoint. This is really, really important, folks. And we tell this to everybody, not only because we believe in the power of mental health coaching and education and support, but we've seen the evidence of folks who go into this kind of incredibly stressful, incredibly scary and confusing proceeding without the right kind of mental stability. It doesn't mean you're not going to be stressed, you're not going to be fearful throughout, but what you should not do is just assume, like sadly I think too many people do, that you're fine, you can handle it, or even worse, that certain people that don't have the training are the ones that are going to help you. For example, maybe the best example, attorneys, right on our business card, on our old business card, we used to say attorney and counselor at law. And that is an accurate title, but counselor only means in the law. It does not mean that we have any knowledge or expertise or competence to give you therapeutic advice. A good lawyer will tell you that they're there to help you, they're there to guide you, they're there to help you go through the process and make decisions on your behalf legally, but they can't and should not be the one that's helping you emotionally and with your mental health. We think it's incredibly important. We think it's important that you think about this and vet someone and bring someone in as early as possible. Now, a lot of folks come to us, maybe even the majority of folks, after they've been through couples counseling, they've been through marital counseling, and it's broken down. In most cases, just like with a financial advisor, you're not going to be able to use the joint therapist to help you in your own individual therapy. Sometimes you can, and I'll leave that up to my friends who are experts in the mental health community to help you navigate that. But most of the time, it makes sense for you to have an independent therapist. I call them a coach. A lot of guys, to be stereotypical, are really silly when it comes to mental health and therapy, and it's perhaps not our fault, because there are a lot of false assumptions around the whole world of mental health. You can call it a coach, you can call it an advisor, a counselor, but you will be benefited, in my humble opinion, enormously by having somebody you can talk to in confidence. That's not your lawyer, not your family, not your friends. If you're in one of these situations, you might have had this experience where everybody wants to help you. And I can tell you that almost always they're really well intentioned. They care about you. Maybe they even they love you, but they don't have the expertise. And this is not who you should be relying on for therapeutic coaching, advice, help. Get somebody who's trained in this area. Avoid the sort of word on the street. Well, my uncle and my aunt and my dry cleaner, and you're going to hear a million different things. All too often, you're going to hear false things. You need experts in your corner: legal, financial, mental health. That's my strong opinion. And it will help you immensely. Consider a therapist not only to help yourself, but also your children. Get some advice from your lawyer on when and how to bring in some intervention for your children. There are some nuances there that are beyond the scope of tonight's call, but a therapist obviously can be of tremendous benefit to your children who are struggling through this process. I put up on this screen sort of a parade of horribles, if you will, forgive me. But just to caution you, I think that it's fair to say that this is an area of law that has perhaps no greater number of fallacies and misconceptions out there. I hear this stuff almost every single day. And believe me, people are generally well intentioned. They're not meaning to deliberately deceive, but there's just so much false information out there. Here are just some of the examples. Number one, that a kid of a certain age gets to decide what age they live at. Is it 12? Is it 13? Is it 15? Is it 16? Is it 18? The answer is no, 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 no. No child in a family law proceeding until they are emancipated, which generally under family law means the age of 19, can decide with whom they are going to live. It's a false premise. Common law marriage, yes, it does exist, but it doesn't require that you have a relationship of some significant period of time or that you live with somebody for a certain period of time. It's false. You could be living with somebody for 30 years and not be common law married. You can be living with somebody for 3 months and yes, be common law married. You need to get some advice if you're concerned about that situation. Colorado is a no-fault divorce state. I can write a book about all the misconceptions around no-fault divorce, but I'll just highlight one of them. No-fault divorce essentially means that the way the judge divides up the money and the property cannot be based on who did what, who committed what fault, no matter what that fault is. If they committed adultery, if they're a drug addict, if they were a domestic abuser, these are all terrible things, and they might impact the child custody part of the case, but they cannot directly impact the financial part of what a judge needs to do in your case. Moms get primary custody always. That's false. I can tell you dads in our practice get primary custody every single day. And the gender biases among the bench is changing over time. It's not quite even, but it's a false premise to assume that only moms are going to get custody of children. Property is not divided 50-50 under Colorado law. Property is divided equitably, and that doesn't necessarily mean equally. So these are just some of the misconceptions out there, all both to give you some tidbits and also to give you some examples of the kinds of things that you might hear, but you should only be getting the final story from your trusted advisors that we're talking about. Okay. next. Let's talk about missteps. Let's talk about some of the mistakes in terms of tactics that people make. And some of them can be a really, really big deal. First of all, this happens all the time. Somebody is perhaps even understandably afraid of a judge dividing up their hard-earned assets, or they're terrified that certain assets they're either going to have to divide or give up to their spouse. So what do? They don't disclose that the assets exist. They hide them. They don't provide documentation. They falsify values. I can tell you, after many years of experience, that in the vast majority of situations, it won't work. It's going to cost you, and it's going to cost you perhaps a lot more than you thought. If you are found to have deliberately or in bad faith failed to disclose, not only are you potentially liable for the value of the hidden asset, but the judge can punish you in a lot of different ways, including ways you may not even realize. It damages your credibility. It damages your ability to argue your side of the case. Don't do it. Don't do it. I would say that whenever we see it, first of all, if it's our client, we talk them out of it in every case that we possibly can, or we withdraw from the case. If it's not our client, we see it happening. We have ways of discovering the true information, and almost always it is discovered, and almost always it's incredibly damaging. Don't do it. I just gave you all of sort of the soft reasons not to do it, soft but really important reasons why it's going to hurt your case strategically. I will also add that you're required to fully disclose everything that's material under Colorado law. You stand in a fiduciary position with your soon-to-be ex-spouse. You have a financial, legal duty to be honest and forthcoming. It's required under Colorado law. I talked about the tools that we have to discover hidden information and assets that are out there. We employ those all the time with success. But before we even get to those things, automatically under Colorado law, each spouse is required to voluntarily disclose a whole host of documents without request and in every single case. Not only that, but you have to supplement that information anytime any of that material information changes in any significant way. Excuse me. This is really important. Don't run afoul of the law for all the strategic reasons, plus the legal reason that you could be fined and it could really harm you legally. Don't do it. Next thing that we tell people, or we suggest people not do, is to deliberately make moves prior to the divorce that you think are going to put you in a stronger position financially. This will almost always backfire, and it's not worth it. Here are some examples. We say no major financial moves of any kind within 6 months, even to a year prior to a divorce. Anything that you do in those months leading up to the divorce is going to be scrutinized, and the judge is going to want to second guess anything you have done. Things like taking a lesser paying job. Bad idea financially, but it's also going to hurt you in your case if you've done it in bad faith. Selling assets, hiding assets. One of the first things we're going to ask when we're asking our clients about all their property is not only what do you have now, but what did you have a month, 2 months, 3 months ago? And if you don't have certain assets, where did they go and why? Anything that you do that is perceived to have been done in bad faith to harm your soon to be ex is going to look very unfavorable for you in the eyes of the judge. This is related to taking a lesser pay cut, refusing promotions, just not pursuing your career. Usually a bad idea all the way around. It's not only not going to help you in your divorce, but it's not going to help you financially. You're going to miss out on the promotion, you're going to miss out on that extra money. And in your divorce, if it's proven that you've done it in bad faith, the judge can act as if you had that promotion with that extra money that you should have taken. So it's the worst of all worlds. Don't do it. Buying, selling major assets, homes, pension plans, retirement accounts, investments. Don't sell this stuff off unless you're doing it in conjunction with your spouse and it's part of a joint plan. It's almost always unwise. Like I said, it will be scrutinized and second guessed after the fact. Okay. Finally, the last set of issues I think might be even the most important. It's the way that you approach the case mentally. And this is Rich talking as a lawyer. This is not Rich the therapist. I'm not a therapist. I don't even play one on TV, but I can tell you about the kinds of folks that are successful over the years and the kinds that are not. And there are certain very clear commonalities that I want to share with you tonight. Number one, your divorce, no matter what, without question, is going to be one of the most stressful, scary, confusing, maybe exasperating things you'll ever have to go through, for sure. And nobody, and certainly not me, is going to tell you that it's easy or that you ought to be detached. What I can tell you is that hopefully with good folks around you, including good mental health advisors, what you can't do is allow your emotions to guide your legal decisions. Emotions are short-term. They're often in the middle of a legal proceeding. They're the negative emotions: anger, spite, fear. These are not the kinds of the kinds of mental states of mind, I should say, that lend themselves to wise, considered decisions. Doesn't mean you shouldn't feel them. You're a human being. You should feel them. If you don't, something's probably wrong. What you should not do is make decisions in the midst of heightened emotions. I tell folks, try to look at the forest through the trees. Yes, this feels overwhelming and scary, and I know at times so very unfair, but you will get through it. There is light at the end of the tunnel. Think about the big picture. And if you can't see the big picture, which means what does your life look like after the divorce? What are your kids where are they going to be? What are your finances going to be looking like? What you need financially to protect you? That's where your advisors come in. You've got to be able to see the big picture and listen to the folks around you that are qualified to help you, and that can help you. Another mistake people make is they might have an advisor, but they insist on doing all the talking or all the negotiating on their own behalf. It's almost always not a good idea. Your expert advisors are there for a reason. Take advantage of that reason. One of the best things they can do is take the burden off of you. Let them speak and write and present on your behalf in their professional manner. Don't try and do it yourself. It's going to be fraught with mistakes and peril. The other thing that happens if you present yourself in a very angry manner or spiteful manner, judges see it, lawyers see it, mediators see it, child welfare experts who are going to be making recommendations about your kids to a judge are going to see it. You want to keep that stuff in check as best you can. You're allowed to be angry. You're allowed to be frustrated. You're allowed to be terrified. That happens. Do it with those around you that you care about. Do it in the privacy of your therapist's office. Hit your pillow in your bedroom. Talk to your buddy over a beer. Listen to a trusted relative and vent as much as you want, but don't do it in the midst of a legal proceeding. It's almost always a mistake, and it'll harm your negotiations position as well. Next, this is a slide that I didn't have in here as of a few years ago, but it's becoming a very, very big deal. We tell people that if there's any chance you can take a break, take a hiatus, a vacation from social media during your legal proceeding, do it. Now, for a lot of us, perhaps it's your comfort zone, it's your community. I don't want you to cut off your friends or your important connections. What I do want you to consider is that anything you type anywhere, no matter how private you think it is, if you've typed it, it may not be private. And people say and do awful things all the time in social media. I'm sure you've seen it. You've probably seen it today. I have. Don't let it become an exhibit against you in a divorce. This stuff is admissible. It comes into proceedings all the time, and it can really hurt you. If you're feeling like your ex is a jerk, pick your adjective, and let's say that's even true. Tell it to your buddies, tell it to your mom, tell it to your therapist, tell it to your lawyer, but don't type it and post it. It's a bad idea, and it could really harm you. Things are taken out of context. What you think is funny or off the cuff may not be perceived that way when it's a snippet taken out of context, and it can really harm your case. It can even harm your attorney-client privilege if you start posting things about your legal proceedings. Well, my lawyer said this. Well, even if your lawyer did say that, don't post that. Please, please don't do that. It can really, really hurt your case. Next, and this is a topic that I have one slide on, but I could easily have 500 slides on because this is something that is really, really important to me and anybody who cares about kids. Keep your kids out of the middle. Keep your kids out in the middle. Oops. Let me explain this a little more, because most people don't come to me and say, yeah, Rich, I know, but my kids need to know what's going on. And I'm just going to tell them that their dad's a jerk. Almost nobody says that. Even if they think that, they don't admit that. And most people don't even think that. They think what they're doing is innocent. They think what they're doing is helpful, and it's often not. We know, I say we, when I say we, I mean the smarter folks in the mental health community that has studied this subject for a lot longer than I've read about. I'm not an expert, but divorce for sure is traumatic on kids. But what studies have shown is that the greatest trauma that kids suffer is not merely the divorce, but more importantly, the level of conflict during the divorce that they personally experience and witness. That's what causes the most profound, long-term scarring trauma. So don't discuss the legal proceedings with your children. don't talk negatively about your ex. It is harmful to them. It's not right. And it's often going to even hurt your case. It's a big, big mistake and almost never will help you. It will often be found out that your child has been coached or your child is hearing negative things about your soon-to-be ex. Parental alienation, parental disparagement, it's a big, big deal. Whether it's a psychological syndrome, for those of you who are familiar with this subject or not, doesn't matter. I can tell you from a lot of experience that it's happening, it exists, and it's a terrible problem. If you're proven to be the one that is pushing your children away from their other parent, it's going to harm your case, and it probably should. Please don't do it. Another piece, switching gears here. This is a tough one for folks to hear, I think, and I think it's something that is not obvious for a lot of reasons, including, I think, portrayals of lawyers and judges in the media, movies, what have you. Maybe it's because so many people have gone through this and they have an opinion and they want to tell you what to do. But there's a common misconception out there that you're going to go through a family law proceeding, whether it's a divorce or anything else, and you're going to get to the finish line and you're going to feel good. You're going to feel like you were vindicated, that you were understood, that your ex was punished in the way that rights the wrongs. I'm sorry to tell you that is usually not the case, as much as perhaps it should be. The legal system is not designed to pick winners and losers. The legal system is not designed to determine who was right, who was wrong, who was the good guy, who was the bad guy. It's not designed to do that. We divide property up equitably. We set out children's issues or child custody based on their best interests. It's not based upon who wins and who loses. And if you go into the proceeding with a mentality that you're going to win, and your side is going to be proven, I'm sorry to say you have a focus that's only going to lead to disappointment at best and really harming you at worst, because you shouldn't be focused on issues related to fault in a no-fault divorce state like Colorado is. Folks, I believe in the law. I believe in justice. Obviously, it's my profession. I care about it deeply. But I'm sorry to say that the family law courts is not a place where you're going to achieve a personal notion of justice in the majority of the cases. So if you set your expectations a little lower and you go into that with that mentality and you keep that mentality, you're going to be better off, in my humble opinion. Okay, next, in terms of your focus, I cannot underestimate the importance of not only having the right mental outlook, but taking care of yourself physically and mentally. These are not small things. You're gonna lose sleep. You're gonna eat junk food. You're gonna mess up on your exercise routine if you have one. That's okay. Give yourself a little grace. But do something. Practice self-care. If you have a good mental health coach or a trainer to help you, fantastic. No matter what, realize the obvious. I think it's obvious. You can't help your kids. You can't help yourself if you're not strong and confident and healthy at least a basic level. You're obviously going to be stressed. It's not going to be easy. But the clients that we work with that realize that they still need to take care of themselves at some level are going to do so much better at all of the points in the case where it really matters. You're meeting with a mediator. You're going for a hearing in front of a judge. You're meeting with a child custody evaluator. You want to be on, you want to be clear, you want to be moderate, the best you can. So take care of yourself. And that includes your mental health as well. It includes your kids. Obviously, you can't be happy and healthy if your kids aren't. And conversely, the converse is true too. You don't have to pretend everything is perfect and that daddy's doing great or mommy is on the top of the world when she's not. But you want to be as healthy and in control and confident as you can be, even if you're upset, because it will help your children a lot. Okay. And so in closing, I just give you what I call the top 10 mistakes that people make. And I'm just going to list all of these. We'll make these slides available, by the way, after the presentation. But these are the items we've talked about this evening. There are many, many more, as you can imagine. But these are some of the big ones that we see again and again and again. So with that, I'm going to pause and I will turn it back over to my partner in crime, Izzy. Izzy, the floor is yours.
All right. Thank you so much, Rich. We really appreciate all of that. And we have quite a few questions. So we're just going to jump right in if I can find them. Okay, there they are. Sorry about that. Okay, first question. Is there any reason why you would not want to have temporary orders and go straight to permanent orders?
Okay, good question. I'll try and repeat the questions. The questioner is asking whether to go to the final hearing. It's called permanent orders right away or directly, rather than taking the interim step of going to a temporary orders hearing. My answer is going to be one of those typical lawyer answers. I'm sorry, but it is what it is. It depends, and it really, really does. All kidding aside, it depends on your circumstances. It depends upon the urgency of your issues. It often depends upon strategic factors in terms of the judicial officers you're appearing in front of. It also depends on how contested things are. It depends on what is going on in your life with the kids and with the finances. Some court counties are more crowded than others, and I will tell you they're almost all very crowded. A divorce is going to take, under Colorado law, a minimum of 90 days no matter what. In most counties in the metro area that we practice in, the divorces are taking 4 to 6 months on average. In some of the counties, especially in the contested cases, it can be more than 6 months or even more than a year. If you're in one of these situations where things are moving less quickly than you would like, you're probably going to need to consider temporary orders during the case.
Okay, thank you. All right, the next one. Okay, if I've made some financial, somewhat major moves within 6 months prior to the divorce, unknowingly, because unknowing my spouse would ask for a divorce, is there a way to show that I didn't make those changes in bad faith?
Great question. So the questioner asks, what about changes I made prior to the divorce starting that weren't made in bad faith? Thank you for the question. It shows you were listening to my remarks. I appreciate that. Remember, we're talking about bad faith moves only. And look, you're living your life. We're all living our lives. Most of us are doing the best we can to manage our finances on a day-to-day, month-to-month basis. Look at it this way. The burden isn't on you to prove that you acted in good faith. The burden is on your soon-to-be ex to prove that you acted in bad faith. So long as you can justify what you did based upon reasonable financial considerations, even if they were mistakes, even if they cost you and your soon-to-be ex money. It doesn't matter whether they were good or bad decisions. Obviously, it matters to your finances and your family, but that's not the legal question. The legal question is, did you make the moves deliberately in bad faith so as to harm your spouse in the proceeding? And that's frankly not an easy thing to prove. So as long as you didn't do it in bad faith, the good news is you're probably going to be okay.
Alrighty. You kind of touched on this, but maybe you can emphasize a little bit further. Does adultery affect anything about the case, include like spousal support and child custody?
Okay, great question. So we talked about, and I'll reiterate, the question is, does adultery affect issues in the case, such as I think they asked about child support, and was it property, Izzy?
This one is specifically spousal support.
Spousal support, thank you. Child support, spousal support, which is also maintenance or alimony. In most cases, adultery or any other kind of fault does not impact those determinations. Now, there are exceptions, but those exceptions are where the misconduct is directly related to the specific financial issue. So, for example, and I'll give you some extreme examples to try and make the point here. We're dealing with a child support case, and in a child support case, oftentimes we're arguing over how much money somebody is or isn't earning. Somebody comes to court and says, gee, I have no money, but then we look further and it turns out that they've wasted a ton of money, or maybe not wasted, but spent a ton of money, taking their girlfriend or boyfriend to Bimini, or buying their girlfriend a fancy car or jewelry. That's squandering marital income. Those are the kinds of situations where it could have an impact. But I caution you, be very, very careful about when and how you present that evidence.
Okay, thank you. All right, I want to keep my kids out of the middle, but they say that they hate their stepmom and don't want to do the visits at my ex's. How do their opinions count?
Okay, great question. And in the interest of time, I think we're going to have to end on this question. It is an important one. And I'll paraphrase. The questioner wants to know, what do you do, or how do you deal with the situation where the kids have a strong opinion about what should happen? Maybe it's about the visits. Maybe it's about where they live. The kids are expressing that opinion to you, believe them. But you're mindful, you don't want to put them in the middle. Good for you. You shouldn't be. There is a way to get their opinion presented to the trier of fact, the judge, without directly involving them, or at least not involving them in the most harmful way. Typically, that involves hiring a child custody expert. It might be something called a parental responsibilities evaluator or a child and family investigator. These are folks often with mental health expertise, whose job it is to make recommendations to the judge about things like visitation and custody. And these individuals are allowed to talk to children. They're required to talk to children in a lot of cases. And in some cases, that's how the children's opinions are made known. What you don't want to do, gosh forbid, is ever bring a child to court to testify. Believe it or not, it's permissible, but it's a horrible idea unless it's incredibly a rare situation where it just has to happen. And we would almost never allow one of our clients to do it. It's terrible. These are ways, though, that you can bring the child's opinions to bear and make them relevant. Allow those voices to be heard, but not in a way that involves you telling them what to do or putting them in the middle, which obviously nobody wants to do and nobody should do. On that, I'm going to need to pause. Forgive me. I see we didn't get to all the questions, but let me close by, again, thanking you. I thank you for joining us tonight. I wish each and every one of you the best in this proceeding, whether you're contemplating it or in the midst of it. I will tell you, based upon working with lots and lots of people over the years, you will get through it. It will be okay. And hopefully after tonight, you'll get through it maybe a smidge easier. Thank you again. I'll turn it back to Izzy. Good night.
Right. Thank you so much, Rich. And thank you all for joining us this evening. As a thank you for joining us on our webinar this evening, we'd like to offer you a free consultation. To schedule your free consultation, give our offices a call and give them the code WISER together to schedule, and they will set you up to discuss with one of our excellent attorneys. If I will reiterate what Rich said this evening, thank you so much for joining us, and we hope you have an excellent Wednesday, and we hope to see you at another Wiser Together webinar. Thank you so much.